John, I think that there's only one way to settle all of these problems.
Yeah, I think I know where you're going with this.
I just don't see any other way that we can get through this. And we have to do what's best for the kids. I honestly think that divorce is the best option.
So where do we go from here?
Well, I don't know. I guess I can go down to the courthouse tomorrow and see.
Mom, what's going on?
Hello, I'm Susan Kimball. And as you can see, ending a marriage can be a very stressful and trying time, especially if you have children. It's a difficult step for most people. Think hard about the emotional, financial, and family consequences before you decide to go ahead with a divorce. We're here to help guide you through the legal process of a Maine divorce with children and to let you know that you are not alone. In recent years, the national divorce rate was more than half the marriage rate. In Maine, several thousand divorces happen every year, and many are filed without a lawyer. We're here to show you some of the ins and the outs of filing for divorce. But before we get into the exact process, there are some issues you need to address. First and foremost, do you need a lawyer? We recommend that you consult with a lawyer if you can afford one. We also suggest getting a lawyer if you have complex property issues, pensions, or retirement accounts, arguments over children, a history of domestic abuse, or other difficult problems. In the case of domestic abuse, we recommend that you seek support from a domestic violence program. The number, 1-866-834-HELP. If you need a lawyer but you can't afford one, you may want to call the Maine Volunteer Lawyers Project, VLP, at 1-800-442-4293. They may be able to provide a lawyer for free, but that's not a guarantee for everybody. Some lawyers are willing to help you with parts of your divorce for a lower fee. If you think you can pay something for limited legal advice, you may want to try the Maine State Bar Association's Information and Referral Service at 1-800-860-1460. If none of these options work out for you, then you may have no other choice but to move forward on your own. At this point, you may be wondering how much this is going to cost. Even if you don't end up with a lawyer's bill, there are some expenses you should expect to pay. These fees are subject to change. Summons forms, $5, filing fee, $120, service fee, $30 to $50, mediation fee, $160, $80 for each party. You can ask the court to waive the fees if you have a low income and you cannot afford them. If at any point during this process you start to feel overwhelmed, stop. Take a deep breath and remember, you are not alone and you can get through this. So let's get started. First, you'll need to get the court forms. If you have internet access, you can download fillable versions of most of the forms you're going to need by going to the Pine Tree Legal Assistance website. However, you must purchase a paper copy of the summons from the court clerk's office. If you prefer, you can pick up forms at local district courts throughout the state of Maine.
I'm getting a divorce and I have no idea which papers I'm supposed to have.
Okay, just a minute. Here you go.
Great, thank you.
You're welcome.
Once you have the forms, you'll need to fill them out. There are instructions on how to do this on the front page of the packet and online. Refer to this information throughout the process. If you have a low income and you need additional assistance, it's available. The Maine Volunteer Lawyers Project offers a helpline for this issue. You may also get help from a courthouse assistance project if there's one at your local court. Many public libraries also offer help with accessing the online fillable forms. Pine Tree Legal also offers online forms that ask you to answer a series of questions about yourself and your family and fills out the forms for you. Once you've finished filling out your forms, it's time to serve and file the papers. You'll need to make 2 copies, one for you to keep and one to be delivered to your spouse. First, you'll serve the copies on your spouse. Then you will file the original papers with the court clerk. The least expensive way to serve the papers on your spouse is hand-delivering them or sending them by mail. Again, follow the instructions in your forms packet. If your spouse refuses to sign them, you can use the service by sheriff method. This means an official will go to your spouse's home or workplace and serve the papers in person. This will cost more, but you may be able to get a fee waiver. Ask the court clerk about this. Once the papers are served, you can file the originals with the court. If you receive court papers from your spouse, you can avoid being served by a sheriff if you sign the Acknowledgement of Service form and send it back to your spouse. You should get an entry of appearance form from the court in the mail, or you can get one online or from the court clerk's office. It's important to fill out and file this form with the court so that you will be notified of court dates. If you do nothing, the court will assume that you do not want to participate. A default judgment may be entered against you, meaning that you will not have any say in the matter. When filing any paper with the court, always mail a copy to the other party or their lawyer if they have one. Make a second copy of all of your court papers, put them in a file, and keep the file updated. Always take it with you when you go to court. It's also a good idea to keep dated notes about what's happening with your case. Remember, the court needs current phone numbers and addresses for you and your spouse at all times. If you change your address or phone number while your case is going on, notify the court clerk in writing. This way, the court can contact you with important information and with court dates. The next step will be a case management conference. Don't worry if this seems to be taking a while. The court takes at least 2 weeks to send both parties a scheduled conference time. If you've waited longer than this, check with the court clerk to make sure that your case is on track. A court magistrate will be there to run the conference. He or she is there to help you understand the court process and to move your case along. The magistrate will help determine the legal issues in your case, where you agree and disagree, and schedule the next steps.
From here is through mediation, property rights, the children, and if you have all these things organized, that will speed up the process.
During this first conference, you will talk to the magistrate about parental rights issues and, if there is time, division of property issues. The more prepared you are, the more progress you can make. If it works for you and your spouse, try to talk before the conference to see if you can work out at least some of these issues. Bring all relevant financial information, such as proof of income and child-related costs, like daycare and health insurance. If you and your spouse can agree on all of the relevant issues and can document your financial picture, then the magistrate may schedule you for an uncontested final hearing. If there are still disagreements, the next step will be mediation. A trained mediator will try to help you agree on additional issues. You must mediate in good faith, but if you feel threatened or in danger because of abuse in your relationship, let somebody know. If at any time during these proceedings you feel threatened, take a break and tell the mediator how you're feeling.
But if there's a day that I'm not at work and I'm in town, I want to be able to see the kids.
If there is a protection from abuse order in place, you can be placed in a separate room. Again, the most pressing issues concern the well-being of your children. During mediation, the goal is to come to an agreement that puts your kids first. Because of this, the mediator will focus on building an agreement on the following issues: how to plan to address parental rights and responsibilities, where the children will live, when the children will have contact with each parent, the amount of child support, how the children's health care will be covered, who will pay for housing costs, and any other issues that will have an immediate impact on the children. After these issues are decided, it's time to move on to other concerns such as spousal support, how you'll divide your marital property, and how you'll divide payment of debts and bills. The mediator will help you write up these agreements on these issues at the mediation session. Now, if you run out of time, but you think you may be able to reach agreement on more issues, the court can schedule you for a second mediation session. Your next step may be a status conference with the magistrate. Once the court has a good sense of where both parties stand on the issues, the magistrate will determine what further steps are needed. It may mean more mediation, or another conference with the magistrate or a judge. As a final step, you will have a contested or an uncontested court hearing. This may be with a magistrate or with a judge. If you have agreed on all of the terms of your divorce, your final step, the formal uncontested court hearing, will be simple. The judge will listen to both of you and to any witnesses you have and make a final decision on unresolved issues. Be prepared and stay calm.
All of the property and financial issues?
Yes.
Okay, it provides for shared parental rights and responsibilities, shared primary residence of your two children, and also a specified contact schedule.
Divorces are tough, but with legal support and support from your family and friends, you can do this. We hope that this information will help you get started. Take one step at a time, ask questions, and remember, you are not alone.
For additional help, please contact Volunteer Lawyers Project at 1-800-442-4293. For online help, including interactive court forms, go to the Pine Tree Legal Assistance website at www.ptla.org/court-forms. For domestic violence help, please contact the Maine Coalition to End Domestic Violence helpline at 1-866-834-HELP. For additional reading, try Do Your Divorce Right by Judge Andrew Horton and Judge John David Kennedy.